On record, call the matter of Yelm versus Nick Reigers. Mr. Nerlich, good morning.
Good morning, Your Honor.
It looks like scheduled for a review with regard to treatment, victim impact panel, etc. In touch with your client?
Yes, Your Honor. He actually he sent me a message not too long ago. I think he was actually going to try to jump on Zoom.
And it looks like he might. Now, Mr. Reigers, are you present?
Yes, I am. I'm having a tough time here. I got some weird things going on with my phone.
We can hear you perfectly well now. I'm going to let your attorney address the matter. The issue.
Thank you, Your Honor.
Is treatment, victim impact panel, the usuals.
Thank you, Your Honor. That's correct. So, Your Honor, last time we were here, Mr. Reigers sort of informed the court that he had gotten his assessment. I believe that was provided to the court, and that he was working on scheduling his first appointment. I was talking with Mr. Reigers, and I think he can probably illuminate the court a little bit better than I can. But essentially, it sounds like there was a bit of a scheduling issue, that he did get his first class scheduled, but then had to reschedule, that there were just some calendar conflicts. So, Mr. Reigers, do you want to sort of elaborate on that?
Absolutely. I just got a class scheduled, and unfortunately, I do emergency work for the city of King County, and I had a scheduling conflict, and I just absolutely missed it. And I've been working on rescheduling at a time that it'll be feasible to make it on. So I've got another couple options where they might have later classes that I can attend.
Very understandable. I guess the question I have: how much time do you need? How much time are you asking for?
I will be scheduling something today. As a matter of fact, part of the group I work with Alcoholics Anonymous, is actually giving me a couple places to do some classes.
Mr. Ratfield, any objection to resending the matter to say June 20th? That's Mr. Nerlich, would that be acceptable to reset the matter to June 20th, with the understanding that if we have proof on file by that date, that appearance is not necessary?
I think that'll work, Your Honor, of course.
Mr. Nerlich, do you understand that? We're resetting the matter to the end of June. Now, if we have proof on file that you've caught up with what you're supposed to do here, you don't need to show up. But I want you to make sure, stay in touch with your attorney and make sure we have proof on file by June 20th, okay?
You got it. Thank you very much.
I'm a firm believer in better late than never, but I'm going to wish you good luck in getting this done. You take care of yourself, okay?
Thank you. You too.
Nerlich, you have a great day.
You too, Judge. Thank you.
Copy of today's order.
Thank you, Judge.
Bradfield, anything to address at this time? Mr. Graves, you're here on a motion to rescind a no contact order. We'll take that matter now. Come on up and have a seat. The order is in favor of a Kia Brantley. I don't see her in the courtroom. She is a protected party here. I would need to, with regard to rescinding the no contact order, I need to hear from her. So well, you do have an arraignment hearing at 1 o'clock. We'll see you back here then, and you can talk to the public defender will be here to help you out. and you can talk to him about the situation, okay? We'll see you back here then. Take care. You step forward, identify yourself for the record, please.
Tyler Sorensen,
Last name?
Sorensen, Tyler James Sorensen.
Sorensen, good morning. Anything you have to tell me
Good morning.
or show me?
Yes, I have my evaluation right here. I
Wonderful.
did have one question about the impacts panel. I was wondering where I could go get that done at.
Usually the same place. Could I see what you have?
Yeah.
Here you go. Come on up and, going over this, what do you think about the recommendation? Well, it sounds like they're recommending intensive IOP, what they call it, intensive outpatient treatment. What do you think about that?
Yeah, they're requesting me that I do AA and mental health. I'm okay with that.
Do you agree?
Yeah.
We all have issues. The most important thing to do is to recognize them at the very beginning and then go about addressing them. And it sounds like Northwest Resources is giving you a pretty good evaluation here. Now, on the victim impact panel, I think Northwest Resources, they either give one or they can certainly direct you to where you get one. So I would check with them on that.
Okay.
They used to be kind of a separate thing, but I think a lot of these treatment agencies have made the victim impact panel part of their process. Is this something we can keep? Is this our copy? If not, what I want you to do is take this to the window and have a copy of this made for our file. Thanks.
You want me to do that right now?
Please. Mr. Sorensen, hold on. I'm going to reset the matter to realizing that it takes a little bit of time to get started here. Let's reset the matter to June 20th. Now, if we have proof on file that you've started the treatment program, Northwest Resources, they're pretty good about filing the compliance reports that they're obligated to do. Hopefully by then we'll have attended a victim impact panel. If that is the case, if we have that on file, proof of that on file, you don't need to show up. How is life going otherwise for you?
It's going pretty good.
You look well, you look healthy. I want to see you keep it that way. All right. Signing an order, rescinding it to June 20th. These are hoops you have to jump through, and hopefully with the recommendation you have, that's going to give you the tools and the information you need to make sure you don't have to come and listen to somebody like me ever again. And I'm sure that's a laudable goal. Okay.
Yeah.
Mr. Sorensen, I'm going to wish you the best of luck.
Thank you.
I'm signing the order resetting it to June 20th. Get a copy of that at the window as well, but make sure we leave a copy of the eval for us.
Okay.
Signing the order electronically at this time. I'll wish you the best of luck.
All right.
Any
thank you.
questions?
No.
You take care of yourself.
You too.
Hey, thank you. Well, may as well go off record, I guess. That's
Morning, Judge. I can't.
Mr. Abaco, good morning. We can go on record if you're ready.
We're the custody officer is hopefully soon returning with some people.
An interpreter here for Mr. Oliveria Garcia.
Okay,
Mr. Mold is in the courtroom, and
I see him, and we'll take that matter first.
to save us a little time, I'll swear him at this point. Solemnly swear or affirm that you will translate from Hispanic to English and English to Spanish all that is spoken here.
Yes, I will.
Thank you. Any idea who they're going to bring up first?
Well, I told them to bring whoever, if they brought a group, I told them to try to bring the Spanish-speaking person along with the first group. So I'm not sure.
With the jail, one is never sure. So.
I'm not sure if they're going to bring Mr. Bingaman because apparently he's detoxing, I guess. So I don't know if he's going to, I'm not sure if he's going to appear or not.
We'll see.
Yeah.
apparently waiting up in jail. We have private people that quickly. Okay, let's take your matter now. Morning, sir. Identify your client for the record and we'll.
Yes, good morning, Your Honor. For the record, Matthew White appearing on behalf of Mr. Brooks, Bradley Brooks. We're on for a pretrial hearing. We also waived arraignment, so he would need to be arraigned as well. As far as the arraignment, if we want to do that first, received a copy of the complaint. We'd waive a formal reading, stipulate probable cause for the purpose of setting conditions, ask that a plea of not guilty be entered. As far as the pretrial today, we're going to be requesting a continuance. I did go over the waiver of speedy trial with my client. We'd essentially be asking for a new commencement date at that next hearing. I was unable to get onto the Wi-Fi here, so I wasn't able to have him sign off on those documents.
I see that the reset is to June 6th at 11 o'clock. I would really prefer to change that to 9. That's.
I think the reason I had picked the 11 was a couple things in the morning. You said that was June 6th?
June 6th. City have any objection to reset? Doesn't matter.
That's fine, Your Honor. We'll make it work. Would the court allow me to appear by Zoom?
Certainly.
If we're just going to be setting that over?
Certainly. Prefer your client to be here in person, but you can certainly appear by Zoom.
Okay. I have an arraignment in Kitsap, but I think I should be able to get that, have the other attorney.
I see the matter set for a pretrial. I presume there's already been an arraignment.
We actually waived arraignment.
Oh. In any event, just to, I may as well say for the record, I'm pretty tired. I'm functioning on trying to recover from a 40-hour day flying here from out of the country. In any event, full name, Bradley Dale Brooks. Citation alleges that on or about April 10th, 2024, you committed the offense of hit and run unattended. That's a misdemeanor. The maximum penalty on conviction would be 90 days in jail and or a $1,000 fine. I take it your attorney is entering a plea of not guilty on your behalf, which preserves your rights. So we're resetting the matter for a pretrial on June 6th at 9 o'clock. Stay in touch with your attorney. Any conditions of release would simply be law-abiding behavior. Stay in touch with your attorney and appear for court. Any questions, Mr. Brooks? No. Good luck to you. I'm signing an order as we speak, resetting the matter to June 6th. I've signed the order, concludes the hearing. Get a copy of the order at the window outside the courtroom to your left. Mr. Brooks, thank you for appearing. Take care. We'll deal with your matter again on June 6th. Have a good day. Take care. The case of Ananda Sakaran. That's an SOC. Let's. Mr. Ratfield, you want to take number 1? Now, Mr. Ananda Sakara, and I believe is how it's pronounced. You want to take that matter now? Yes. Your attorney's present on Zoom, so come on up and have a seat. And again, if there's a way of mispronouncing a name, I'm going to find out how to do that. In any event, I apologize to you. Roy Masigo, we'll take your matter now. Your client is in the courtroom and seated at the council table as we speak. Matter set for a pretrial. I'll defer to you for the status of the matter.
Yes, Your Honor. I spoke with prosecutor on this yesterday, and and my client, I do believe we have an agreement on an SOC. I'm signed into O Courts. However, I can't make anything open in O Courts for the SOC. I just have little gears turning around. So,
It looks like the simple terms of it are a 6 months continuance with an amendment to neg 1 upon compliance with the conditions, which of course would be the standard law-abiding behavior, et cetera, and a $250 probation monitoring fee.
that's what I discussed with my client, and he doesn't have anything in the last 7 years. So I assume there's no other conditions as far as um, interlock or anything like that. I think we're prepared to proceed. It's just that I don't know if I will be able to click on whatever you need me to click on. He's prepared to sign, though.
Being a computer dinosaur, he appears to have a hard copy of the instrument in front of him. And
As long as he doesn't have any additional questions before he signs, I think we're prepared to go forward.
do you want to talk to your attorney, or are you ready to go proceed with it? We'll do that then, subject to revision later, of course, should there be a problem due to counsel's inability to obtain a copy in front of her for purposes of this hearing. I'm going to apologize to you for mispronouncing your client's name as well. I'll try to avoid doing that for the rest of the hearing.
I think you're pretty close, Your Honor.
We have what you have is a contract here with the city, under the terms of which this matter can be reduced to a much less serious charge if you comply with the conditions. Your attorney has put you in a very favorable position here, but it's up to you as to whether or not you take advantage of that or not. As I've said many times, that a conviction for DUI is more serious in terms of impact on your life than a lot of felony convictions. So if you can get this reduced to a neg 1, negligent driving in the first degree, that's the best result you could possibly want in this. The most important thing is to learn from the mistake. Don't repeat it. Stay out of trouble. The conditions here are pretty simple. They simply require you to appear for court, have no criminal law violations, and do not drive with blood or alcohol or drugs in your system, and no alcohol-related infractions, and no refusal to take a breathalyzer of any kind. The $250 costs, you can pay it $50 a month starting June 3rd, 2024. The important thing to remember is this: in return for the agreement, you've given up your rights to go to trial. If there's a violation of the agreement and the city proves that, we'll have a hearing based on the police reports, and that would almost certainly result in a conviction for DUI, bearing mandatory jail time, license suspension, a lot of things you don't want to even think about. Insurance premiums are also a major concern. Do you have any questions about what you've gotten yourself into here? For what now? No, you would not. What I want you to do is make sure we have a current address on file, and your attorney knows what your address is. We're not going to reset it for any hearing at this time, and there won't be any hearing unless the city alleges that you've violated the agreement. If you're in compliance, we review the matter in 6 months and automatically amend it to negligent driving first degree. Ms. Sigo, anything you'd like to add or comment on?
I just want to make sure, Mr. Andisgar, if you have any questions and you don't want to go forward today, that's fine. But if you feel like you understand everything that we discussed yesterday and the paper you have in front of you, if you want to go forward, we could go forward today.
Want to go forward today?
Yes, please.
We can go forward today. I will have your client, the doc will indicate that the instrument has been served on him, and I will say on the record, I will gladly entertain any motion to reconsider, revise, et cetera, should a review of the instrument lead to any questions at all. I'm entirely open to that.
Yep. Counsel, if upon opening the agreement, it's not what you expected, please just email me or give me a call and we'll revise accordingly.
I think per our discussion yesterday, I don't think there's anything that we're missing. So it just, other than my ability to crack the OCORT code.
That was being a computer dinosaur myself. I totally understand that.
So, do we need Mr. Anandaskaran to sign on the, do you have a?
We have the record, and the instrument indicates that he's served with a copy of the order. I've signed off on it now, and sir, you can get a copy before you leave by going to the counter, and they'll prepare you one. And we're going to send one to your attorney as well. Okay. I'm going to wish you the best of luck. Again, if we don't learn from our mistakes, and we all make them, we're condemned to repeat them at some point in time. Drinking and driving, it's something, those are activities that you need to entirely separate. I'm going to wish you the best of luck. I'm hoping that in 6 months, I'll be able to review the matter and reduce the charge to a much less serious one. Okay, you take care of yourself. And don't forget to get a copy at the window. Sigo, we'll be sending you a copy as well. You take care of yourself, and have a good day.
You too, Your Honor. Thank you. Bye-bye.
And the jail is still working on that. And we have number 2, Tyler Anderson. Yeah, let's take that. Good morning, Ms. Backus. We'll call the matter of Yelm versus Tyler Anderson at this time, set for a pretrial. I see a instrument in the OCORT system resetting the matter to June 6th at 9 a.m.
Yes, Your Honor, please. I am waiting for an offer from Pierce County. The other jurisdictions have agreed to transfer jurisdictions, so now I'm just trying to get an offer out of the county.
Any objection from the
Pierce.
city? Hearing no objection from the city, I'm signing the order resetting the matter to June 6th. We'll be sending you and your client a copy of today's order, and good luck with the other matter.
Thank you very much, Your Honor. Appreciate it.
Take care of yourself.
Everybody else, bring men have a seat in the ground chair. Everybody else have a seat in the big ground chair. In the first 2 rows. Okay. Tiger. Right, that chair. Okay, bring men have a seat in the back row. Yeah, that's fine.
What have see here? Thank you. Your Honor, this is Mr. Hector Oliveria Garcia.
Good morning, sir. We do have an interpreter in the courtroom. He will assist you with the hearing. I'll let Mr. Mould to say good morning to you at this point.
Buenos días, señor. Tenemos un intérprete aquí en la corte para ayudarle. Le voy a dejar a él a presentarle a usted.
We're here for an arraignment. We proceed with that.
Estamos aquí para una lectura de los cargos. ¿Debemos proceder con eso?
I explained to the defendant what an arraignment is.
Expliqué al defendiente. The interpreter did not get that last part.
Oh, I'm sorry. So with the assistance of the interpreter, I reviewed with the defendant what an arraignment is.
Con la ayuda del intérprete, revisé con el defendiente lo que es una lectura de los cargos.
And that would be to be read the charges in open court.
Y leemos los cargos en la corte.
The elements that the city would have to prove.
What was the last part again?
The elements that the city would have to prove.
So the city would have to
Oh,
prove.
los elementos que tendría que comprobar la ciudad.
And the maximums that could be imposed.
Y el máximo que podría imponer la corte.
With that in mind, the defendant has chosen to waive arraignment and enter a plea to the charge.
Y teniendo en mente, el defendiente ha decidido denegar la lectura de los cargos y entrar una declaración de culpabilidad.
Hey, thank you. Sir, is your full name Hector Oliveria Garcia?
Señor, es su nombre completo, Héctor Olivaria Garcia.
Hector M.
Yes, it is.
Do you disagree with anything you've heard so far?
Está en desacuerdo con cualquier cosa que ha oído hasta este momento.
Así es.
Yes, it is. He answered differently. Quiero asegurar, señor Olivaria Garcia, usted está en desacuerdo con cualquier cosa que le ha dicho hasta ahora.
Estoy de acuerdo.
No, I'm okay.
Okay.
The plea form I'm looking at is to one count of theft, third degree.
Estoy mirando un cargo. El formulario que estoy mirando tiene un cargo de robo de tienda en tercer grado.
Theft, third degree has a maximum penalty of 364 days in jail and or a $5,000 fine.
Y robo de tienda tiene una penalidad máxima de 364 de violación y $5,000 de multa.
I would be free to impose that regardless of what's recommended.
Y yo estoy libre para poder imponer eso, sin embargo, lo que ustedes han llegado a estar de acuerdo.
Have you gone over the plea process with Mr. Haverco, your attorney?
¿Ha revisado el proceso de entrar una declaración con su abogado, señor Haverco?
And you realize that you give up the rights contained in paragraph 5 if I accept the plea.
Y usted entiende que está denegando los derechos que están incluidos en el párrafo 5 si yo acepto su declaración.
The defendant having nodded, Mr. Oliveria Garcia, as to one count of theft in the third degree alleged to have occurred in Yelm on April 5th, 2024. How do you plead, guilty or not guilty?
Señor Olivaria Garcia, concerniente al cargo de robo de tienda en el tercer grado que supuestamente pasó el 5 de abril 2024 en la ciudad de Yelm. ¿Cómo se declara usted? ¿Culpable o no culpable?
Culpable.
Guilty.
Do you make that plea of your own free will?
Y lo hace usted esa declaración de su propia voluntad?
Así es.
Yes.
Anyone threaten you or promise you anything to make you plead?
¿Hay alguien que le ha amenazado o le ha prometido algo para hacer que usted haga esa declaración?
Para nada.
No.
I'll find your plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements.
Voy a encontrar que su declaración ha sido hecho libremente y voluntariamente. Y encontrar que su declaración en el párrafo 11 que contiene los hechos para encontrar esos hechos.
Así es.
Okay.
The city is recommending suspended jail time and a $250 fine.
La ciudad está recomendando tiempo de encarcelación suspendida y una multa de $250.
Perfecto.
Mr. Oliveria Garcia, do you have anything you would like to tell me?
Señor García, ¿tiene usted algo que usted le gustaría decir?
Agradecerle.
Mr. Haverco, anything you'd like to add?
Señor
Nothing to add other than, I did ask, Mr. Oliveria Garcia if the court were to impose a fee, would he be able to pay? He said when he gets out, he normally works. So, apparently he does believe that he would be able to make good on a financial obligation on release.
Le expliqué al defendiente acerca de que si la corte impondría un honorario, si él lo podría pagar, y me indicó que podría hacerlo por medio de trabajo y hacer los pagos.
Sir, you're in jail because you didn't appear for court when you were supposed to.
Señor, usted está en la cárcel porque no apareció en la corte cuando tenía una fecha y debería haber asistido.
Así es. Me dijo el policía que tenía un guardia por no haber ido a la corte.
¿Podría repetir eso? No entendí bien por la conexión.
Así es. Me dijo el policía me dijo que tenía un guardia por no haberlo presentado en corte.
Okay, so yes, that's true. And
Follow the recommendation, 364 days in jail, all suspended on condition of behavior.
todos los días de encarcelación va a estar suspendido bajo la condición de comportamiento siguiendo las leyes.
I'm not inclined to impose any fine at all, and will waive payment of the fine.
No estoy inclinado de imponer ninguna multa en este momento.
Muchas gracias.
That concludes the matter, unless you have any
Yes, sir.
questions, Mr. Oliveria.
Eso concluye el asunto, aparte de que usted tenga alguna pregunta, señor Olivaria García.
Nada más quiero agradecerle.
No,
I wish you good luck.
le deseo mucha suerte.
Muchas gracias. Your Honor, this is Kate Long.
Ms. Long, good morning.
Good morning.
She's on for a compliance case and an arraignment on assault for pretrial hearing on a theft charge. First things first, on the arraignment case, she would like court-appointed counsel on that case, Judge.
Good morning, ma'am. Is your full name Caden Long?
It's Kate Nicole Long.
Caden Nicole Long, excuse me.
Right.
Mr. Haverco, I was distracted there a little bit. I assume that I'm looking at a statement of defendant on plea of guilty to one count of theft, third degree. Is that the proposed resolution?
It is, but Your Honor, if you wouldn't mind for record keeping, could you order that I'm appointed on the arraignment matter?
Mr. Mr. Ratfield, anything to add?
Nothing to add, Your Honor.
Mr. Haverko, I'm not hearing everything quite as clearly, and your camera.
Oh, I was asking, Your Honor, would you appoint me on the new arraignment matter as court-appointed counsel? I've reviewed that file with them.
And the camera there seems to be a little bit. Nothing we can do about that. Right? Ms. Long, I'm looking at a statement of defendant on plea of guilty to one count of theft in the 3rd degree. Plea form tells me you're 19 years of age. Is that correct? Have you gone over the plea form with, do you need a moment? You're shaking your head no.
No, I don't need a moment.
Theft in the 3rd degree is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, which could be up to the maximum regardless of what's recommended. What's recommended is all suspended jail time. And I'm not seeing any recommendation of a fine, Mr. Haverko.
That would be correct.
Ms. Long, with that in mind, as to one count in the 3rd degree alleged to have occurred within the city of Yelm on February 29th, 2024, how do you plead, guilty or not guilty?
Guilty.
Make that plea of your own free will.
Correct.
Anybody make any threats or promises to you to make you plead
No.
guilty?
No.
Find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements. City, have anything to add to the recommended sentence? Mr. Haverko, anything you'd like to add?
Nothing else, Your Honor.
Ms. Long, you have a right to tell me anything you want me to know at this point. I'll hear from you if you have anything to say. You don't have to say anything, but now's the time if you do.
I know.
I'm going to follow the recommendation, sentence 364 days, all suspended on the condition you have law-abiding behavior. I'm dismissing the assault, 4th degree charge. Ending in 060 as part of the plea agreement. The city taking any action with regard to compliance?
Nothing right now, Your Honor.
Ms. Long, you're in jail for one reason. You've missed court, I think, 8 times without us hearing from you. That's the reason you're where you are right now. Stay out of trouble. That's a condition of the sentence, law-abiding behavior. That's why the jail time is suspended. And appear for court as directed, okay? If you don't show up for court and we don't hear anything from you, that leaves us with no option except to issue a warrant. Unless you have some other hold on you, you'll be released on this charge today. Good luck to you.
Wait, so I'll be released from jail today.
Yeah.
Thank you, Judge Myers.
Yes. Yes.
I'm not sure.
Okay.
You do have
Okay.
clients. We're kind of stuck.
Do you want to be released? Do you want to be released? Yes. This is Mr. Bingaman, Your Honor.
Good morning, Mr. Bingaman. How are you?
I'm okay, sir. I learned my lesson.
Mr. Bingaman, you're here for an arraignment. I'm going to turn to you. I'm going to appoint Mr. Haverko to represent you in this matter. Mr. Haverko, anything to add at this point? Except to
Well, we did, pursuant to the arraignment, we would stipulate to probable cause, ask the court to enter a not guilty plea, and then would like to address release conditions.
A full name for the record is Kevin Bingaman.
Yes, sir.
Cited on May 5th, 2024 with the offenses of driving while intoxicated. That's a gross misdemeanor. The maximum penalty on conviction to be 364 days in jail for a $5,000 fine. You're also cited with NVOL, no valid operator's license without ID, and also failed to transfer title within 45 days. Those are misdemeanors of maximum penalty, 90 days in jail and or $1,000 each. Mr. Haverco is pleading not guilty on your behalf. I take it at this time, waiving any further formal advisements or rights, stipulating to probable cause.
Correct, yeah, stipulated probable cause, Your Honor.
We'll set the matter for a pretrial hearing. City have any position on bail or release?
No, Your Honor.
Mr. Haverco?
He'd like to be, I think Mr. Bingman would like the court to know he'd like to be released on his own recognizance. As he just earlier stated, he's learned his lesson and he'll do his best to stay out of trouble while on release and not committing criminal law violations. So I think that's what he's asking.
Please, Your Honor. Please, can I have this one more chance?
Mr. Bingaman, that's you were in court here just last month, a couple of weeks ago.
I understand. I was just moving the vehicle. I live in my truck and I'm homeless, so that's why I can't park overnight. That's all I was doing, was moving my vehicle from spot to spot.
The new citation is one of the most serious that I deal with, driving while under the influence. Right after you were in court, addressing, I think, 8 different matters, many of which were dismissed, but there was a plea to the others. I'm sort of inclined to keep you in jail on bail, pending the...
Please, Your Honor. Please.
You don't seem to display any ability to stay out of trouble.
No, I can't. I promise you, I don't have my vehicle anymore either. It got impounded, so I can't drive it anymore anyways, and I'm homeless. So I'll be able to make court and everything like that, because I have people that can give me rides and stuff, but I don't have my vehicle anymore, so I'm not going to be driving it anymore.
Mr. Bingaman, I will PR you on your promise to stay out of trouble.
Thank you.
For a pretrial on May 23rd, if that's available. Now listen to me, and I want you to remember this. Any criminal offense, whether it's trespass, NVOL, it doesn't matter to me. Any criminal offense, and you're going to be sitting there on bail until you post it or until the matter's resolved completely. This is what, your 9th charge in Yelm in a fairly short period of time. That doesn't speak well.
Okay.
You are presumed to be innocent on these charges. That presumption continues through a resolution of the case. I'm going to strongly urge you to stay out of trouble. Okay?
Okay, thank you, Your Honor.
Low profile. Small community. Everybody knows exactly who you are on site. And so it's very important that you just simply stay out of trouble. Do what you're supposed to be doing. Okay. Good luck.
Okay.
See you on the 23rd.
Okay, thank you.
11 a.m. Stay in touch with Mr. Haverco.
I'm being released today. I'm released today.
Judge, on this, Shipline. She apparently was having a blood sugar issue, so staff took her back to do some kind of blood monitoring, and then I was just informed that she doesn't want to come back for court today. She just wants to go to bed and go to sleep. So I guess we'll just check the in custody roster in a couple weeks and see if she's in custody. Maybe she'll want to deal with it.
She's PR'd on our case. This is simply a DOC hold.
Right.
Just monitor it.
Yep.
We'll see.
Yep. Okay.
You now address the matter. Fernando Preciado Lopez. Good morning, sir. Good morning, sir. We're here on two matters. Mr. Mold will help you with these cases. You were cited back in February for NVOL, no valid operator's license. You didn't appear, so the $611 fine was imposed at that point.
So 650?
611. Is there some reason you didn't respond to us?
I had, when I had the ticket, I had called the number that was on the ticket. And so the person that spoke Spanish on the phone told me that I had until like the El 20 de Julio, like the 20th of July in order to get my license. And so then they gave me like a month so that I could then get my license and show up at court when show that I have a license. So I went, I did not, no se presentó en la corte. So I went to go to fill out the, to present my papers so that I could get a license, and none of that happened. Y entonces se presentó, no se presentó. And so that's why I did not come.
Hey, you're here because you don't have a license and you were driving.
Y usted está aquí porque no tenía una licencia y estaba manejando. Monday. So, yeah, and I've got my work that I'm making pallets here in a greenhouse. And so I use my license. I have to drive between my work and my house is all I have to drive.
That was, well, that's a choice we make.
Eso
If,
es una decisión que
it's
hacemos.
illegal, it's against the law.
Es ilegal, es contra la ley.
And if you get caught doing it, there's a fine.
Y si le agarran haciéndolo, entonces hay una multa. And that's why I had another one for my license too. And I'm in Nova Santos. Oh, and so I'm trying to get my license here at
Oh, okay.
and I'm trying to get my license here at 9/11.
Okay, that's all we can do is, what I'm gonna do is, yeah, the 611, that's too much. I think 150 for each infraction is sufficient. And we're gonna set your payments on that at $25 a month.
Pienso que 611 es demasiado, entonces voy a fijar una multa de $150 para cada infracción. Y usted puede hacer pagos de $25 al mes.
Hey, but get your license. I realize you're in a difficult position. Gotta work, but I don't have a license. How do I get there? That's a problem that a lot of people have, but get that license as soon as you can.
Más pronto que pueda. Hay mucha gente que está en la misma situación, que tengo que ir a trabajo y cómo voy a llegar a hacerlo. Pero saca la licencia lo más pronto posible. Okay. Okay, so, and also at work, they gave me some few days so that I could study to get my license.
Good luck.
Buena suerte.
I'm gonna sign, the order is signed. You can get a copy of that, Mr. Moldo. Get you to the right point. Get a copy of it at the window. And if there's a problem making the fine payments, let us know.
Si tengo algún problema en haciendo los pagos, avísenos. I had some other payments to make. I don't know if the court can wait for me to make payments.
Do what you can.
Haga lo que pueda.
And if you can't make a payment, let us know.
Y si no puede hacer un pago, avísenos.
We'll be patient. We'll work with you.
Vamos a ser pacientes y vamos a trabajar con usted.
Pay something. If you can pay 25 a month, if you could make that fit, if you can't, at least pay something so we don't lose track of it.
Paga algo. Si puede hacer pago de $25, por lo menos está haciendo un pago.
Because if you don't make the payments, you might have your ability to get a license suspended.
Si no haga los pagos, podría ser que pierda la posibilidad, el privilegio de sacar la licencia.
Good luck. Get a copy at the window and
Puede obtener una copia acá. Okay,
take care of yourself. And you as well. Hey, Mr. Mo, good to see you. Hey, it's Back on record, I presume for the 9:45 hearings. Is Gavin Connolly here? Is not. How about Justin? I do not. Justin is here. Mr. Davis, good morning again. Mr. Davis, you've got to learn to come to court when you're scheduled.
I was at the bathroom at the park and I.
That happens. You're here now. That's the important thing. In any event, you were cited for a criminal trespass first degree on April 15th, 2024, and you were cited for a reckless burning second degree on April 17th, 2024. I'm going to appoint Mr. Haverco to represent you in these matters. I'm appointing him to represent you, and he's going to enter a plea on your behalf with regard to these charges, and we'll set the matter for a pretrial. Okay?
Stipulate to probable cause, Your Honor, on both matters. And ask the court to enter not guilty, please.
Mr. Davis, we're going to reset the matter for a pretrial on June 6th, 10 o'clock in the morning, signing an order to that effect at this time. Now, I need you to stay in touch with Mr. Haverco and stay out of trouble. That's a condition of release. Law-abiding behavior. And the warrant is quashed. Mr. Davis, the order of reset is now signed. It has your date and time on that. I want you to go to the window outside the courtroom and to your left. Get a copy of that. Stay in touch with Mr. Haverco, and we'll see you back here in June. Any questions?
Nothing.
Good luck.
Peggy Eckhorn.
Morning, ma'am. Is your full name Peggy A. Incorn? Ms. Incorn, the citation alleges that on or about April 8th, 2024, you committed the offenses of theft third degree. That's a gross misdemeanor. The maximum penalty and conviction would be 364 days in jail and or a $5,000 fine. You're also cited for the use of drug paraphernalia. Misdemeanor, maximum penalty and conviction would be 90 days in jail and or a $1,000 fine. I'm going to appoint Mr. Haverco to enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor. Ask the court to enter not guilty, please.
Ms. Incorn, a plea of not guilty preserves your rights. I'm appointing Mr. Haverco to represent you in this matter. We're going to reset the case for a pretrial conference. It gives you a chance to. Trial will be June 20th, 10 o'clock in the morning. We'll prepare an order to that effect. I want you to get a copy of that at the window outside the courtroom to your left before you leave. Conditions of release are law-abiding behavior, and stay in touch with Mr. Haverco. Report back to court when scheduled. Ms. Incorn, any questions? Good luck to you.
And Adam Pevin is here. It's a compliance issue.
Mr. Bevan, how's it going?
Oh, well.
It's a sentence compliant issue. You went into warrant status because you didn't show up for a hearing. Any reason why?
I do not.
Always a good idea to make a mental note when you get an order, setting a court date to show up. Also, if you don't have a mailing address on file, make sure we have one so mail gets to you.
Yeah, I live in Burlington, so.
Why don't we reset the matter to June 20th and address it at that time? In the meantime, the warrant is quashed, okay? And Mr. Pevin, get a copy of today's order at the window. That's it. Let me catch up with the Cahill Williams, good morning. Turn to your attorney for the status of the matter.
Matter comes on, 3 matters come on for pretrial hearing this morning. What we've been trying to do is to set it over until such time as his treatment provider is willing to recommend lifting or rescinding the no contact order. He has been in treatment for a while. And so his hope is at some point he will achieve that. And then it's at that time we're anticipating that parties will be able to work out some kind of settlement of the matter.
How far out do you want to go?
How much more last time did you get to? I'd set it out 8 weeks. That'll give him time to go to several more classes, and maybe by that time, might be able to get a recommendation by then.
About how far? June
About
20?
8 weeks.
About 8 weeks?
Yeah.
July 18th looks like. July 18th.
Okay.
Gail Williams, I'm reviewing a letter that's on file from the Department of the Army, submitted by your treatment provider there. That's a little concerning here. A paragraph begins with the observation that the family is anxious for the protection order to be lifted, but then it goes on at the bottom of the court. It says it appears that the family and Mr. Cahill is utterly ignoring the contact order. The family has been clear that they will not comply with services until the service member is allowed to return home. Hey, we've got to get the chicken before the egg, They need to comply with the any treatment recommendations. And until they do, there's not going to be any lifting of any no contact order. And it sort of looks like you're sort of going and coming as you please to the home. Now, we've had a couple of incidents here, one where they had to find you hiding in the home. I don't want to set high bail on you and have you reside in jail until the matter is resolved. So you've got to start abiding by the no contact order. It's there for a reason. Sign the order resetting the matter to June 18th at 10 o'clock. Mr. Cahill Williams, I want you to get a copy of this today's order at the window outside the courtroom to your left, and we'll see you back here in July. Take care of yourself.
Ms. Hill on the 10 o'clock?
Good morning.
Good morning.
Hill comes on for a pretrial hearing on a theft charge. Parties have reached an agreement, that being a stipulated order of continuance, and continue the matter for 12 months on the condition of no new criminal law violations, pay a $250 court fee, at the end of which time the city would move to dismiss.
Good morning, Ms. Hill. Your full name, Heather Marie Hill, for the record. So I'm looking at a SOC, stipulated order of continuance, on this screen in front of me here. It's what it is a contract between yourself and the city, negotiated by your attorney, under the terms of which this case can go away. It can be dismissed if you comply with the conditions of the agreement. The most important one is stay out of trouble. No criminal law violations. The lesser important one is the $250 probation fee, which you need to get that taken care of before the end of the period of the agreement, which is 12 months. Now, if you violate the agreement and the city proves that, you haven't given up your rights in paragraph 5 for the return of for trial. If the city proves a violation, we'll have a hearing based on the police reports, and that would most certainly, almost certainly result in a conviction for a gross misdemeanor. Don't want to go there. You have a chance to get this case dismissed. I want you to take advantage of the opportunity. Any questions at all?
No.
We all make mistakes. What we have to do is learn from them and not repeat them. What I want you to do is go to the window, get a copy of the agreement. Look it over carefully and then give Mr. Havercole a call if you have any questions about anything that's in the agreement. Any questions of me? Yes, $250 over a period of time. You can make the payments at the window or by mail.
Okay.
Good luck to you, Ms. Hill. Take care of yourself. Thank you.
Thank you.
Lucas Peters.
Morning, sir. Full name Lucas Evan Peters. Defer to your attorney.
So this matter comes on before the court, pretrial hearing, and the parties have reached an agreement, that being a stipulated order of continuance. Continue the case 12 months, no new criminal law violations, $250 court fee, at the end of which time the city moved to dismiss.
Mr. Peters, you disagree with anything your attorney just said? Again, this is a contract. I want to make sure you understand this. You may have already heard this. It's a contract negotiated by your attorney with the city under the terms of which this charge, gross misdemeanor, non-conviction, that you could go to jail up to 364 days or get fined $5,000. You got a chance to get this case dismissed. Two things: stay out of trouble. That's most important. And two, $250 monitoring fee. These no contact orders are there for a reason, and no contact means no contact. If there is an order to that effect, you're not to have any contact. Hopefully, a year from now, we'll be able to simply close the case, dismiss the charge against you. Now, in return for the agreement, you've given up your rights to go to trial, have witnesses, and if there's a violation of the agreement, we'll just have a hearing based on the police reports only. It's important that you keep that in mind. Any question at all? I want you to go to the window outside the courtroom to your left, get a copy of the agreement, review it carefully, and if you have any questions, give Mr. Havercole a call, okay? Good luck to you. Mr. Peters, take care of yourself.
Next matter will be Matthew Reeves.
Mr. Reeves, come on up, have a seat. For the record, your name is Matthew, middle initial S. Reeves. Right.
The matter comes on before the court for a pretrial hearing on a theft charge. It's an older case, and parties have reached an agreement. He's going to enter a straight plea to the charge. The recommendation is just a suspended jail time, a court fee, and at the end of which time the case can be closed.
This is Matthew Reeves.
Correct.
What I'm looking at, I've got a SOC on the,
You do? No, there's a guilty plea, courts
there I am.
under Reeves.
I was looking at the wrong thing. Again, for the record, your full name, Matthew, middle initial S. Reeves. Mr. Reeves, I'm looking at a statement of defendant on plea of guilty to one count of theft in the 3rd degree. Have you gone over the plea form with Mr. Haverhill? And if you had any questions about what it meant to enter a plea of guilty to a criminal charge, was your question answered?
Yeah.
Plea form tells me 41 years of age. Any problem reading, understanding the English language? Theft third is a gross misdemeanor, the maximum penalty, 364 days in jail and or a $5,000 fine. Now there's going to be a recommendation, but regardless of the recommendation, I'd be free to impose up to the maximum if I thought it appropriate to do so. You realize that. If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing. With that in mind, as to one count of theft in the 3rd degree alleged to have occurred within the city of Yelm on August 11th, 2019, how do you plead guilty or not guilty? Do you make that plea of your own free will? Anybody make any threats or promises to you to make you plead guilty? I will find the plea to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy. There is no statement.
There is not.
But having reviewed the police reports, I will find that there is probable cause for the issuance of the citation and to accept the plea.
Must have disappeared.
Well, maybe if I hit the refresh button. Mr. Reeves, the recommended sentence is all suspended jail time, suspended on condition of law-abiding behavior, and a $250 monitoring fee. Is there anything you'd like to tell me? We all fall down. It's good to see somebody who's decided to get back up and did so. My hat's off to you from that. For that, I'm of course going to follow the recommendation. All jail time suspended on the condition of law-abiding behavior, and I don't think you have anything to worry about there. That's case has been around. That goes back to 2019. It is high time to get it over with, and it sounds like you're on a much better road at this point. What I want you to do is get a copy of today's paperwork at the window outside the courtroom to your left, and look it over. Any questions, give Mr. Haverhill a call, and we'll go from there. In any event, congratulations getting the matter wrapped up, and you have a good one. Take care of yourself.
Take care. Mr. Shea?
Need a moment. Any shot?
Is this your number? Yeah, I called it on 420 and 57. I've never had a problem. Yeah, called you 2 days ago. I can't help you with the case. You want help with it? This is Mr. Shea. It's item number 12 on the 10 o'clock calendar. Going to ask for a reset. Have put in a motion to continue with the speedy trial waiver in O courts. Asked to reset it in the ordinary course.
About how far out would you like to go?
4 to 6 weeks. 4 to 6 weeks.
Well, July 20th, or June 20th, I'm sorry. July 2nd or 18th? Oh, got it. We're not doing
18th.
Okay, at the request of your attorney and yourself, we're resetting the matter. Stay in touch with Mr. Haverco in the meanwhile, law-abiding behavior of courts. And we'll see you back here July 18th, 11 o'clock in the morning. Any questions at all? I'm signing the order of reset at this time. Go to the window and get a copy of it. We'll see you back here towards the end of July. Good luck.
Okay. Next matter would be Titus Williams. I believe the city has a motion on this case. Dismissal without, I think the city.
Yeah, Your Honor, moving to dismiss without prejudice.
Titus Williams. The city is moving to dismiss without prejudice. What that means is that based on further information or reconsideration by the city is free to refile the case. Williams, I'm signing the order of dismissal at this point, electronically, of course. You're free to leave. If you want a copy of today's order, you can get it at the window outside the courtroom and to your left. Any questions at all? Take care of yourself.
Mr.
Tim Riddall. Docket number 11. I don't see Tim in the courtroom anyway.
I haven't had any contact with him.
He used to just show up on a regular basis, but it seems the last few times he's sort of not.
Right.
City have a motion?
City moves to do more.
So ordered, unless he shows up before the end of the day. If he isn't here now, I don't expect.
On Killian Barrett, item numbers 2, 3, and 4, he had contacted me that he wanted a continuance because I don't know whether it was word, something was taking him out of town. I tried to figure out when he'd be back, but so it just has to note the failure to appear for.
Who's that again?
Killian Barrett. Would ask the FTA be noted for speedy trial purposes and then reset.
Noted
with notice.
For speedy trial purposes, reset the matter as requested.
And Christine Albert, she's not here, but when I met with her at her arraignment, she indicated she didn't have a phone, so I haven't had any kind of contact with her.
City have a motion?
Yeah, city moves to more.
So ordered. unbear it, of course, send a notice. I didn't say so. Back to the 8:15s, we did have some no-shows. Docket number 1, motion denied. Docket number 2, Avery Mason Feeder. Failed to appear for 1,000 cash or bond, warrant issue. Chandra Pesca, as I recall, we have issues with her. So ordered, 1,000 cash or bond. Jeffrey Rowe. Having reviewed the yeah, let's reset that to June 20th. Jeffrey Rowe, nothing on appearance. It's compliance though. Based on his telephone call, reset to hopefully by then, the victim impact panel will be set up. We did. That I missed. Gavin Connolly, I guess simply strike the hearing, leave the warrant in effect, and that
This is Ms. Dunnigan on the 11 o'clock calendar.
Good morning, ma'am. Full name Alexis Dunnigan.
Website. I don't think they really expect it because if he violated never at the time, we'd have to. So they're still offering you an SOC dismissal. Yeah, I appreciate it. You know. So we've placed, Ms. Dunnigan comes before the court for a pretrial hearing on a protection order violation. Parties have reached an agreement. We placed a stipulated order of continuance in Oak Courts, conditions of which are continue the case for 12 months on the condition of no new criminal law violations. Pay a $250 court fee, at the end of which time the city would move to dismiss.
Ms. Dunnigan, have you gone over the SOC, the agreement with your attorney? It's a contract, basically, between yourself and the city, negotiated by your attorney, under the terms of which 12 months from now, this charge can be dismissed. Go away. Whether it does so or not is up to one person. I'm looking at it right now. You need to be in full compliance with the law. That'll include anything relating to any protection orders. And you need to pay, much less importance, $250 by way of a probation monitoring fee. Now, in return for the agreement to get the charge dismissed, you've given up your rights to go to trial. If the city proves you have violated the agreement, we'll have a hearing based on the police reports, and that would almost certainly result in a conviction for a gross misdemeanor bearing up to 364 days in jail and up to a $5,000 fine. I realize that there's a lot of personal issues that are involved in these protection order situations. It's just part of life to work through and go forward. I hope that 12 months from now, I'll simply be able to close the case, dismissing it. What I want you to do is get a copy of this agreement at the window, right outside the courtroom. Look it over carefully. And if you have any questions about what it means, give Mr. Haverco a call, okay? Any questions of me? You can pay it, set your payments at $25 a month. Now, if there's any issues, is that going to work? You can pay whatever you want. Yeah, this is the most important thing to me is learn from the situation. But if you want to take care of it today, you can certainly do so at the window as you get a copy of the agreement. I'm going to wish you the best of luck. Okay, take care of yourself.
Good luck. Brianna Jones. So this is Brianna Jones. Matter comes before the court for pretrial hearing on assault fourth-degree domestic violence charge. Parties have reached an agreement. City's going to amend the charge to disorderly conduct, to which I prepared a statement of defendant on plea of guilty for her. She's made a statement. And then further, the city is recommending a deferred sentence as opposed to a suspended sentence. So she complies with paying the court fee and committing no new criminal law violations. And at the end of 12 months, the case could be dismissed if Your Honor goes along with that recommendation.
For the record, full name Brianna Amira, last name Jones. I'm looking at first things first, I'm looking at a statement of defendant on plea of guilty to one count of disorderly conduct amended down from a an assault charge. Plea form tells me you're 27 years of age. Any issues reading, understanding the plea form? You went over it with Mr. Haverco and he answered any questions you might have had. Now, disorderly conduct is a simple misdemeanor. The maximum penalty and conviction to be 90 days in jail and or a $1,000 fine. If I accept the plea, you give up the rights contained in paragraph 5, no trial, no witnesses, no appeal, simply a sentencing, which could be into the maximum. With that in mind, as to one count of disorderly conduct, alleged to have committed within the city of Yelm on March 17th, 2024, how do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? No. Find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements. So, Mr. Haverco, with regard to sentencing,
Just asking she has a couple little charges, unrelated as a juvenile. And so she's had nothing like this on her record. And so, that was kind of the reason the city was willing to amend the charge to disorderly conduct. And again, asking Your Honor to follow the deferred sentence recommendation such that if she complies, this case can be dismissed off of the record.
City, have any objection?
No.
Ms. Jones, anything you'd like to tell me? Anything you'd like to tell me about the situation? If you have anything to tell me, now's the time. You don't have to say anything. I think the recommendation is a fair one. I'm going to follow it. Defer sentencing for a period of a year. If during the year you comply with the I'm having computer difficulties here. It's not, and I'm not good at divided attention. If you stay out of trouble for a year, pay the costs suggested. The charge is simply going to be dismissed. You'll be allowed to withdraw your plea and automatically, and the charge will be dismissed. Try to say once. Said please sign. Oh, no, it just flipped around. Let's yeah. She does. Goes on. Jones, I'm now signing the judgment and sentence form. Sorry for the delay. It's the O-court system is sometimes a little shaky, shall we say. Signing the paper, I want you to get a copy of that at the window outside the courtroom to your left. And if you have any questions after you read the instrument, give Mr. Evergo a call. Now you have a chance to get this thing gone for good. You need to take advantage of that. So I said a few moments ago, sometimes these situations involving domestic issues, I won't go any further to say, but they get very emotional and sometimes veer out of control. You need to learn from this and make sure things are handled in a different way in the future, shall I say. But I'm going to wish you the best of luck. We all make mistakes and we have to learn from them. That's just reality. But good luck to you. You take care of yourself.
Next matter would be Michael Parker.
Good morning, sir.
Matter comes before the court this morning for a pretrial hearing on a theft charge. Parties have reached an agreement. He's going to enter a straight plea to the charge. All suspended time, next 12 months, no criminal law violations, pay a $250 court fee, at the end of which time the matter can be closed.
Good morning, sir. Full name, Michael Don Parker. Mr. Parker, I'm looking at a statement of defendant on plea of guilty to one count of theft, third degree, which is a gross misdemeanor, the maximum penalty on conviction, 364 days in jail and or a $5,000 fine. Plea form tells me you're 40 years of age. Any issues at all? Any problem going over the plea form with your attorney? Any problems going over the plea form with your attorney? And if you had any questions about anything in it that meant anything, were your questions answered?
Yeah.
If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, which could be up to the maximum regardless of what's recommended. You realize that. With that in mind, is the one count of theft, third degree, alleged to have occurred within the city of Yelm on March 13th, 2024. How do you plead guilty or not guilty? Do you make that plea of your own free will? Anybody make any threats or promises to you to make it plead? No. I will find your plea to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements of the offense. Now, the recommended sentence is all jail time suspended, $250 fine. Is there anything you'd like to tell me?
So I'm not working.
No, oh no. City have anything to add?
Try your best. If not,
I will follow the recommendation in part. All jail time, 364 suspended, $250 fine. But yes, we'll set the payments on that at $25 a month. Now make the payments if you can, and if that's just not working out at all, yeah, get a hold of Mr. Havercoat, get back on the calendar, and we can go to community service or sometimes. Something I have found that if people ask for community service, sometimes they come back to court and say, you know, hey, look, it's just easier to pay the fine than to do that. Pardon?
$250
$250, $25 a month. $25 a month. Do what you can. Just do what you can.
Sign here. That's the judgment sentence.
Parker, I'm going to wish you the best of luck in signing the judgment and sentence. What I want you to do is go to the window, get a copy of today's paperwork, read it over carefully, and give Mr. Havercoat a call if you have any questions. Any questions of me? No. Good luck to you. And again, the most important thing here is stay out of trouble. The fine, I'm not too worried about that. So. Yes. Hey, thank you, Mr. Barker. Good morning, man.
This is Karen Moyna, comes before the court for a review hearing. She had here on for a kind of status hearing, trial confirmation sort of hearing for bench trial, I think on March 28th. The docket, she had failed to appear. I think she may have been in travel status. So I believe this is the first appearance back in court. So I believe that we just want to reset a new bench trial date at noon.
This is Tina Dawson.
Oh, this is Karen Moyna.
I didn't catch the last name.
Moyna.
Got it.
Yeah. She's item number 9 on the 11 o'clock. It looks like a notice came back under undeliverable, so we may want to just verify the right mailing address.
Mr. Moyna, yeah, we need to get mail to you. That's been updated. Oh. Problem everywhere. Today, the important thing now is you're here. You're here, and we can address the matter. And want to set it for
Another bench trial, a noon bench trial, and then also set a trial confirmation hearing a couple weeks prior.
You want to go May 23rd, June 6th?
That's fine.
June 6th?
Sure.
20th? Okay. Moyna, it's we need you back here. You'll get a copy of the order today. We need you back here on May 23rd. 2 weeks from today. That's called a confirmation hearing. going to trial is a fairly serious thing. We need to know any motions that have been made have been ruled on. That's something you need to discuss with your attorney.
Well, what happens is when courts set a trial, because it uses up a lot of resources, they want to make sure you're going to be there. So they typically set another hearing shortly prior to the trial date, where everybody shows up and just says, yes, we're still going to trial. You know, that's a common procedure. No, yeah, criminal cases, you have to be present.
That's why you pled not guilty, and that's why we're going to trial.
Right.
The city, you're presumed to be innocent until your guilt is proven by evidence beyond a reasonable doubt. That's it. No, as Mr. Haverco said, going to trial is a fairly serious thing involving a lot of preparation and a certain amount of expense. That is why we have a confirmation hearing prior to the trial date to make sure everybody's ready to go to trial, rather than show up on trial date and with a bunch of witnesses and well, we need a continuance because we need to get something else. In any event, we're setting a confirmation hearing for May 23rd. That's 2 weeks from today, and the bench trial will be held on June 6th. Ms. Moino will sign an order to that effect, and we'll see you back here on May 23rd. Now, we're not relying on the mail to get you notice. We're doing it in open court. That'll take place on May 23rd. So I'm signing the order. It has the court date and time on it. Get a copy of it at the window outside the courtroom to your left, and we'll see you back here in 2 weeks.
Yeah, before you go, you need to sign the order. Yeah, go and sign here. Both signed. See you in 2 weeks.
Just point out, thank you, and you take care.
Yep.
Morning, Ms. Farina. We'll call your matters now. We're here in connection first with are you able to hear me?
I can, Your Honor. Thank you.
Sean Cortado.
Yes, Your Honor. I believe this city has a motion.
Yes, Your Honor. City's moving to dismiss without prejudice.
Hearing no objection to the entry of the order of dismissal, I'm signing that in open court at this time.
Thank you, Your Honor.
I take it you're waiving your client's presence at this.
Yes, Your Honor. I am. He is appearing through counsel pursuant to 3.4.
You have one more matter on the calendar, and that is Tina Dawson.
Your Honor, yes, Tina Dawson, and then I'm also filling in for Tim Lewis on Brendan Danahay. But first, the Tina Dawson matter. I've uploaded a motion to continue in O Courts. I'm asking for some additional time. Ms. Dawson is appearing through counsel pursuant to 3.4. I believe the city and I have a resolution that I anticipate us entering at the next hearing. I am asking the court, though, for permission to have Miss Dawson enter that disposition on Zoom. She's currently living out of state, and to avoid having her travel back to this state to enter the disposition, I'm asking the court for permission to have her do that via Zoom, as long as I've had an opportunity to go over the paperwork with her in advance.
Did you have any objection? Hearing no objection, certainly. She may appear by Zoom.
Thank you, Your Honor.
Reset to June 20th at 9 a.m. Sign an order to that effect and send your client and it says there's a docket entry. We need a good mailing address for your client.
And I will have my paralegal file that, Your Honor.
Okay, that way we can send her a notice as well. Matters reset, 6:20, 9 a.m.
Thank you.
Take care. Have a good day.
Oh, Your Honor, I'm still here on Tim Lewis's matter, Brendan Danahay.
That's it. Brandon Danahy, one more to go.
Yes, Your Honor. That is 4A0339091. Mr. Lewis uploaded a motion to continue in Oak Court. He's asking for some additional time to discuss a potential resolution with the prosecutor.
And filing a document in Oak Court's reset to June 6, 9 a.m. City have any objection?
No objection.
Hearing no objection. I'm signing the order resetting the matter to June 6th, and we'll be sending Mr. Lewis and the client, Mr. Danahy, a copy of today's order.
Thank you, Your Honor.
Thank you, ma'am. You take care. Have a good day.
You too. Bye.
Item number 6, Brianna Faulkner.
Brianna Faulkner?
I did have a number. I called, I've left a message. I've never received a return call, so I have no information.
1,000.
So ordered, 1,000 cash or bond.
Same thing as to Lynn Johnson, left a message, haven't heard back.
1,000 cash or bond, so ordered.
And then on Jennifer Weller, I made a note that she told me at her arraignment, she doesn't have a phone,
Ah,
so no contact information.
well, kind of still up to her to show up. It's, city want a warrant?
Yeah.
1,000 cash or bond, so ordered. Back on record for the 11 o'clock calendar, docket number 1. Have a new clerk in court due to a conflict. Mr. Burnham has been in the county jail on a felony related charge since March, I believe. He was to appear today for a protection order violation, but being in custody, of course, he cannot. City have a motion. Any suggestions from
Well, I suppose did he read that?
And of course, we probably have no idea whatsoever. Given the fact that what I'm attempted to do to preserve jurisdiction is enter a real low bail, $250 warrant just to preserve jurisdiction, not knowing how long he's going to be in custody. And that could be for a while, not knowing anything about the case. Mortal issue, 250 cash or bond. And that concludes the morning calendar. Will be in recess. Good afternoon. I'm going to now call the 1 o'clock arraignment calendar. That's your first appearance after the issuance of a criminal citation. Before I call you up one at a time, I need to advise you that you have a right to have a lawyer represent you at all stages of any criminal proceeding. Mr. Caverco, our public defender, is seated at the council table. He will enter a plea on your behalf at this hearing and will represent you throughout the course of your case should you be indigent and desire his services. Typically, a plea of not guilty is entered at the arraignment, preserves the matter for a pretrial. Pretrial is a chance for you to go over your case with your attorney, negotiate a possible resolution of the case. Sometimes that's not possible, in which case you have a right to a public and speedy jury trial in the county where the offense was alleged to have been committed. If you have any questions about your rights, about what you're charged with, ask either myself or Mr. Havercoom. Is Derek Berger here? Derek Berger. A number of people will not answer after everybody has been processed. A warrant will issue for the arrest of the non-appearing individual if there was probable cause to issue the citation. Derek Berger does not answer. Oh, Derek Berger, come on up. You're a little bit late. Today, have a seat. Full name, Derek, middle initial N, Berger. Citation alleges that on or about April 29th, you committed the offenses of assault, or excuse me, DWLS 3rd degree. That's a misdemeanor. Maximum penalty on conviction would be 90 days in jail and or a $1,000 fine. You're also cited for failing to have ignition interlock when required to have it. That's a gross misdemeanor. The maximum penalty on conviction for that would be 364 days in jail and or a $5,000 fine. I'll turn to Mr. Haverco for the entry of a plea on your behalf. He's the public defender. He'll represent you throughout the course of your case if you're indigent. But at this point, he'll at least enter a plea on your behalf.
Stipulate probable cause, Your Honor, acts the court Anderson, not guilty, please.
Mr. Berger, a plea of not guilty preserves your rights. We're setting a pretrial for June 20th at 11 a.m.
Go and write it on this one.
I want you to exchange contact information with Mr. Haverco and get a copy of today's order by going to the window outside the courtroom and to your left. That'll have the time and date of your next court appearance on. Any questions at all? Good luck to you, sir.
Yeah.
Raymond Bickle in the courtroom. Raymond Bickle. Runiat Carlis. White Crease. Good afternoon, sir. Is your full name White William Crease?
Correct.
Mr. Grace, the citation I have alleges that on or about April 28th, 2024, you committed the offense of driving while under the influence of intoxicants. Now that's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. You're also cited for driving a license suspended or revoked 3rd degree, simple misdemeanor, 90 days in jail and or a $1,000 fine would be the maximum sentence if you were convicted. I'll appoint Mr. Haverco to represent you. He'll enter a plea on your behalf at this time.
Stipulate the probable cause, ask the court to enter not guilty, please.
Plea of not guilty, preserve your rights. We'll set the matter for a pretrial, exchange information with
Oh, sure, I can. Yeah.
ignition.
Okay.
Mr. Grace, based on the fact that you do have a prior back in 2018, I'm going to require that you install ignition interlock on your motor vehicle and file proof that you've done so with the court within the next 5 days. Other conditions of release are don't drive unless you're licensed and insured. Do not refuse to take a breathalyzer if you're asked by any law enforcement officer to do that, and do not drink and drive under any circumstances.
Your Honor,
I don't have the vehicle anymore.
How long is it gonna stay in impound? How long will it be in impound?
It's gonna be here till, they sell it.
The order will then be don't drive any vehicle unless it's equipped with ignition interlock. Grace, that concludes the matter. I want you to get a copy of today's order by going to the window outside the courtroom to your left and look it over carefully and appear back here for court when directed. Any questions? Here, take care. Michael Daniel in the courtroom. Michael Daniel. Good afternoon, sir. Is your full name Michael George Daniel? Mr. Daniel, the citation I have alleges that on or about April 25th, 2024, you committed the offense of reckless endangerment. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine.
Can I explain that?
Not at this time. You can do that. At this time, all we do is entertain a plea. Now's not the time to go into the facts of the case. I will appoint Mr. Haverco to represent you. He's going to enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
Mr. Daniel, a plea of not guilty preserves your rights. Pending a pretrial, like I explained earlier, pretrial, that's a chance for you to discuss the case with your attorney. Tell him what happened and try to resolve the matter if you can without having to go to trial.
Okay.
Just write your phone number then. Okay.
Daniel, thank you. Take care. Oh, Robert Lee Frank in the courtroom. Robert Frank. Sir, is that your full name? Robert Lee Frank? The citation I have alleges that on or about July 21st, 2022, you committed the offense of driving a license suspended or revoked second degree. That is a gross misdemeanor. The maximum penalty upon conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to represent you at this time to enter a plea on your behalf and throughout the course of the case if you're in the.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
Mr. Frank, a plea of not guilty does preserve your rights. I want you to exchange contact information with Mr. Haverco.
Yeah, sign it.
Frank, that concludes the matter. I want you to get a copy of today's order at the window. Read it over carefully and we'll see you back here at your pretrial date. Any questions? Good luck. Condition releases, of course, is don't drive unless licensed and insured. How about Craig Gross? Is Craig Gross in the courtroom? Good afternoon, sir. Full name Craig Ernest Gross. Citation alleges that on or about April 28th of this year, you committed the offense of driving a license suspended or revoked third degree. Given the nature of that charge, the city may well have a motion.
City moved to amend to no longer second.
You know what that happened? What just happened? As you walked in here, you were charged with a criminal offense that could put you in jail for up to 90 days if you were convicted. The city has amended the charge to a civil infraction. The civil infraction means if you admit it, I can impose a fine and that's it. If you deny it, you're entitled to a contested hearing. But there being no possibility of jail time, you're not entitled to an attorney. You admit or deny that you didn't have a valid license on your person when you were cited. NVOL, no valid operator's license. Second degree, meaning you're identified. I'm going to impose a $150 fine, but I'm going to also ask you, do you know what you need to do to get your license back? We live in a world where you pretty much have to be able to drive to function at all. That's so I'm going to urge you to make that a project in life, okay? Mr. Gross, I'm signing an order to that effect. $150 payable at $25 a month. First payment June 9th. I'd rather you spend as much money as you can in your license. It's money. Reinstated. Do you know how long it's going to take? Oh boy. It's helping you with it. I'm going to wish you the best of luck with that. And here we are adding to the grief a little bit. At least it's not a criminal charge anymore. Mr. Gross, get a copy of today's order at the window outside the courtroom to your left. And good luck on getting relicensed. Take care of yourself. Denny Henneman in the courtroom. Denny Henneman. How about Sherry Hitt? Sit, come on up and have a seat. Good afternoon, ma'am. Is your full name Sherry Keene Hitt? Sherry. Hey, thank you. Citation alleges that on or about April 25th, 2024, you committed the offenses of DWS third, driving a license suspended, revoked third degree. That's a maximum of 90 days and or 1,000. Upon conviction, you're also cited for failure to have ignition interlock when required to do so. That's a gross misdemeanor. The maximum penalty for upon conviction for that would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to represent you, and he'll enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor. Ask the court to enter not guilty, please.
The plea of not guilty has been entered on your behalf. Again, that preserves your rights. I want you to exchange contact information with
Okay. 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 Wait a second. Can't do it yet. So right now in front of me. So too.
Any questions, ma'am? I want you to get a copy of today's order at the window outside the courtroom to your left. We'll see you back here on June 20th. Take care. Thank you, ma'am. Crystal Hogan. Good afternoon. Full name Crystal Midland and A. Hogan. The citation I have alleges that on or about April 28th, you committed the offenses of driving a license suspended, revoked third degree, and failure to stop and give information to an officer. Misdemeanors, the maximum penalty and conviction, 90 days in jail and or $1,000 fine. I'll appoint Mr. Haverco to represent you in this matter, and he'll enter a plea on your behalf at this time.
Stipulate to probable cause. Ask the court to enter not guilty, please.
Plea of not guilty, preserve your rights.
Okay. You'll get my information later, yeah. Fine. Wait a second.
hearing. Don't forget to get a copy of today's order at the window. Any questions at all? Hey, thank you for appearing. You take care. Christina Kitchens, there's a note here to dismiss that case. We'll come back to that. Andrea Krognes was not going to appear. We'll come back to that matter as well. Jonathan Liu in the courtroom. Not yet. Oh, they are. Oh, they are. Okay. Well, okay, bring them up. Good afternoon.
Good afternoon, Your Honor. And I believe Mr. Liu is on the call. And thank you for allowing us to appear virtually. Mr. Liu has moved out of state, but would be entering a plea of not guilty. At this time, we would waive formal reading, stipulate to probable cause for the purpose of setting release conditions.
Thank you, Mr. Gargoyle. Is your full name Jonathan C. Liu?
Yes, Your Honor.
Citation alleges that on or about April 28th, 2024, you committed the offense of DUI. Gross misdemeanor, the maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. Your attorney's entered a plea of not guilty on your behalf. That preserves your rights. Any conditions of release are going to be: don't drive unless licensed and insured, don't drink and drive, and don't refuse to take a breathalyzer if any officer asks you to do so. City, have anything to add?
Nothing to add, Your Honor.
That being the case, Mr. Gargo, what would be the best date for a pre-trial?
Could we do June 6th if that's available? I believe that's a Thursday.
June 6th does work.
That'd be fantastic if we take that day.
Mr. Liu, that would be at 9 o'clock in the morning. Stay in touch with your attorney. That's another condition of release.
Yes, Your Honor.
In the meantime, I'm frozen on. I'm having trouble with O courts today. They're now frozen on me. Before I will eventually sign an order to the effect of reflecting today's hearing, we'll send you and your client a copy of today's order. Do we have your client's address?
If not, I will provide it to the court after the call today, and I will make sure to get him a copy as well. I can pull a copy off of O Court, Your Honor.
Thank you. Order is now signed. And Mr. Liu, any questions about the matter? Stay in touch with your attorney and we'll see you again next month. Take care of yourself.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, counsel.
Autumn Mankey in the courtroom. Autumn Mankey. Good afternoon, ma'am. Full name Autumn, middle initial N, Mankey. Citation alleges that on or about May 1, 2024, you left a child in a vehicle with the motor running. Misdemeanor, the maximum penalty on conviction to be 90 days in jail and or a $1,000 fine. I'm going to appoint Mr. Haverco to enter a plea on your behalf at this time and represent you throughout the course of the case. Should you be indigent and request his services.
Stipulate to probable cause, Your Honor. Ask the court to enter not guilty plea.
Plea of not guilty preserves your rights pending the pretrial. I'll sign an order resetting the matter to June 20th at 11 a.m. Conditions of release are law-abiding behavior. Simply stay in touch with Mr. Haverco. Frankie, this is taking a little longer than I wished it would, but that concludes the matter. If you've exchanged contact information, get a copy of today's order at the window, and we'll see you back here in June. Richard Metzinger does not answer. How about Kirk Morey? Good afternoon, sir. Full name Kirkpatrick Morey. Mr. Morey, the citation alleges in honor about April 26, 2024, you committed the offense of driving a license suspended or revoked third degree. Given the nature of the charge, the city may well have a motion. This is docket number 17, page 14.
Yes, Your Honor, city needs to amend to no faults.
Mr. Morey, same thing happened a few moments ago. The charge was amended from a criminal offense to a civil infraction. No longer any possibility of jail time. If you admit the infraction, it's a $150 fine. If you deny it, we can set it for a contested hearing at a later date. Any questions about anything I've just said? Pardon?
I accept it. Do I know how big?
150. You'll deny it? Okay, we'll set it for a contested hearing. Corey, again, it's important you appear for the contested hearing. If you don't, the matter will go to the Department of Licensing. It's a failure to appear. Just deepen any difficulty that you might have with regard to the license. Contested hearing is set for June 6th at 2:30 in the afternoon. I'm signing an order to that effect. I want you to get a copy of the order at the window. Now, condition of release, of course, I'm like to encourage people to, don't drive unless licensed and insured. And if there is an issue with the license, make it a project in life to get it resolved. Mr. Morey, good luck to you. You take care. We'll see you back here in June. Joseph Murray in the courtroom. Good afternoon, sir. Full name Joseph Josiah Allen Murray. Sir, the new citation alleges in honor about February 2nd, 2024. You committed the offenses of theft in the third degree and 2 counts of a controlled substance, knowing possession of the substance. Those are gross misdemeanors. The maximum penalty for a gross misdemeanor is 4 days in jail and or a $5,000 fine. In the instance of a controlled substance conviction, the maximum would be 180 days for the first offense. I'm going to appoint Mr. Averco to represent you in this matter, Mr. Murray, and he'll enter a plea on your behalf at this time.
Stipulate to probable cause. Ask the court to enter not guilty, please.
Plea of not guilty will preserve your rights.
Sure.
Where there's also calendared a diversion agreement with regard to a December 12th, 2022 charge. The docket indicates that the SOC ends in September of this year, and there haven't been any payments made on it. It's we'll calendar that matter along with the new case. But you should discuss that with Mr. Averco as well.
For sure. Sure, better than anything's better than nothing. Probably was 250. You can do it however you want.
Barry, I want you to get a copy of today's order at the window outside the courtroom to your left, and stay in touch with Mr. Haverco, and we'll see you back here in June. Good luck.
My O courts is stuck. Oh, not, it just moved. Yeah, just moved.
Charles Panis does not answer. Jeffrey Lee Kichocho. I'm mispronouncing that, I'm quite sure. Quichocho. Does not answer in any event. How about Ann Rankin? Ms. Rankin is here. I have to confirm for the record, your full name is Anne Marie Rankin. That's it. Ms. Rankin, the one criminal charge that you have is today is driving a license suspended, revoked, 3rd degree. Again, misdemeanor maximum penalty on conviction to be 90 days and or 1,000. You also have two infractions, or one infraction, no insurance, and one other criminal matter, failure to transfer title within 45 days. That also is a misdemeanor. City may have, however, a motion with regard to each of the criminal charges.
Yep, city, sorry, you said each, Your Honor?
It's now no valid operator's license 2nd degree and expired tabs. So that leaves you with 3 infractions. You can admit some or all of them, you can deny them, and we can set it for a contested hearing. Ms. Rankin, it's your choice. Any questions?
I would just admit. Yeah. Okay, good. Yeah.
You're going to admit the infractions? Do you know what you need to do to reinstate your license? Money. It's a matter of money. I'm going to just assess 150 on each of them. That's a total of 450, but we'll set the payments at 25 a month. But please don't drive unless you're licensed, insured, and do your best to get your license reinstated. Please, as soon as you can. Ms. Rankin, I'm signing an order reflecting the ruling in this case. I want you to get a copy of that at the window outside the courtroom to your left, and give us a call if you have any questions. Good luck to you. Paul Reed, I do not see. Austin Sanchez, I do not see either. Tammy Chauvier.
She was in jail.
No,
Oh,
that
she's
was,
here. Okay.
that was another.
Oh, okay.
Good afternoon, Tammy. If I mispronounce your last name, I apologize. Chevalier, I apologize. In any event, it's Tammy Denise Chevalier. Citation alleges it on or about April 25th, 2024, and then it again alleges on April 24th, 2024, 2 days in a row, you were cited for driving a license suspended or revoked 3rd degree. Pardon? The city have any motion? Well, sometimes with 2 charges like that, I could understand the city not wanting to amend the charge to the infraction, but the city's willing to do that. Instead of 2 criminal offenses, you have 2 infractions, both no valid operator's license, 2nd degree. If you admit those, that's 150 each. If you deny them, we can set it for a contested hearing. Any questions? Do you admit or deny? Also, 150. We'll set the payments at 25 a month. What I want you to do is use your money to get your license reinstated, okay? Order is now signed. What I want you to do is get a copy of today's order. Give us a call if you have any questions, and good luck getting reinstated. Mr. Chevalier, thank you very much. Number 30 will recall. 31 is reset. Jebediah Stecker. Good afternoon, sir. Full name, Jebediah Joseph Stecker. Mr. Stecker, the citation alleges that on or about March 29th, 2024, you committed the offenses of use of drug paraphernalia. That's a misdemeanor. The maximum penalty and conviction to be 90 days in jail and a $1,000 fine. You're also cited for knowing possession of a controlled substance. Gross misdemeanor, the maximum penalty 180 days in jail and or $1,000 fine. Also cited for knowing possession of a prescription drug. Same offense, same penalty, maximum 180 days in jail and or a $1,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf at this time.
Stipulates probable cause, Your Honor, ask the court to enter not guilty, please.
Mr. Stecker, plea of not guilty preserves your rights. Now, conditions of release are going to be stay out of trouble and no consumption of controlled substances. Mr. Stecker, the death rate from the consumption of controlled substances is just out of hand. Save your life, okay? That you should talk to Mr. Haverco about that. I'm going to wish you the best of luck. You take care of yourself, okay?
Before you go, do one more thing.
Second, yeah, get a copy of the order at the window. Terry Thomas. Good afternoon, sir. Full name, Terry Norman Thomas. Mr. Thomas, citation dated April 22nd, 2024, alleges that on that date, you committed the offense of theft third degree. That would be a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll have Mr. Haverco enter a plea on your behalf, and he'll represent you for the duration of the case if you're indigent.
Stipulate probable cause, Your Honor, ask the court to enter not guilty, plea.
Thomas, say a plea of not guilty.
I'll be contacting you. So just wait a second. That's sign something. Go ahead, sign.
Thomas, the order is now signed. I want you to get a copy at the window, and we'll see you back here on June 20th. Okay. Hey, you as well. Take care. Good afternoon, ma'am.
Okay. Oh, I think you were, let's see. Okay.
Number, give me a number.
Faulkner, F-A-U.
What's your last name?
So, speedy trial would reset, so I would ask the court has already issued a warrant. I guess I asked to quash the warrant and reset. So starting with 2 months when you serve, 2 months when you get paid off. She's gonna serve 2 months in the Thurston County Jail, starting on the 13th. So she thinks she would probably get 1/3 off for a good time. So I guess I would try to, pick a date after her release. Do you have any idea when you make your release? No. Because I know
The trouble with, it's a loitering drug related position. It's not, in my view, a serious matter. Give me a number and we'll set it for then.
So how many days are you gonna do? I would set it out 6 weeks. She says she has to do a month and a half. She has to do a month and a half in custody, which means after a good time, that would be at least a month. So I would suggest setting it out 6 weeks, because I think 30 days would be too close.
It's fairly early. Do you guys want to maybe try and resolve it at this point? Or are you anxious to leave? I'll leave it up to you. We can reset it. Call the matter of, Ms. Faulkner.
The city is moving to dismiss without prejudice.
City has moved to a dismissal without prejudice. I think the only thing I'm going to say at this point, ma'am, is the drugs we have out there are killing, they're killing a lot of people, and it looks like virtually everything is getting pretty severely laced with fentanyl. You know, if, that's safe. Hang in there, hang in there. I'm going to wish you the best of luck with that. That was, when do you have to report to the county? Good luck, you know, stick with it until you get there. You should be in fairly good hands when you get to county. Time will pass, and you'll be out. Yeah, don't give up on yourself, but you know, don't give up. But yeah, it's you know, THC, marijuana. If it's just a joint that's not produced directly out of a legal pot shop, it very well could be laced with fentanyl. I ran across a case yesterday in a different court with a situation where somebody got in a lot of trouble medically by unknowingly ingesting fentanyl instead of just a little marijuana. I'm going to wish you the best of luck upon presentation. I'm going to sign an order of dismissing the case without prejudice. That means the city has the option of refiling it, and if you stay out of trouble, you're never going to have to think about it again. Good luck to you. You're free to leave. You have a good day. back on record for the no-shows from the 1 o'clock calendar. The first one I have is Raymond Ray Bickle, docket number 3, docket number 2 and 3. Docket number 2, Dito third, amend de novo 2, and an FTA for that together with the 2 other infractions, no insurance and failure to extend registration. Next one I have is Reniak Carley's. PC was previously found when he was arraigned in custody by Judge Pro Tem Tallmeyer. Warrant will issue for his failure to appear, 1,000 cash. Next one I have is Denny Henneman. That's the next page, page 13, docket number 9, find probable cause for theft second degree attempt and malicious mischief third degree. That's the tractor supply case involving. We have a co-defendant later. Find PC for the issuance of those citations, 1,000 cash. Next would be Christina Kitchens. There's a memo in the file to dismiss that, signed by Officer Mooney. Simply dismiss. Next one would be Andrea Progress. Page 14, docket number 13. We have this very well put together request for a hearing. I released her yesterday. She assured me that no problem getting to court today, but apparently that's not the case. She indicated to Sonia that hey, he told me that on the phone, which note the non-appearance and resent for next available court date, that being May 23rd. No show. Next would be Richard Metziger. Probable cause was previously found for the issuance to him of the site for disorderly conduct, arraigned in custody, went arraigned in custody by Pro Tem Ballmeyer. 1,000 cash upon. The next one would be Charles Dennis. Find probable cause for knowing possession of a controlled substance, 1,000 cash upon. And Mr. Pichochu, he's the co-defendant of the Henneman case earlier. Find probable cause for NDOL without ID and also for theft 2 by way of attempt and malicious mischief third degree. 1,000 cash upon each. Next would be Paul Reed. Probable cause was previously found when he was arraigned in custody for loitering, drug-related, controlled substance, knowing possession, and paraphernalia. 1,000 cash upon warrant will issue. Austin Sanchez, I do find probable cause for DUI and for Noval. Given the DUI, 5,000 cash upon. Christian Walsh. Now amend the Dito third to Noval 2 and the failure to transfer title to expired tabs and FTA to the Department of License. 5,000 each, I think, 5,000. The three, yeah. Let's go back on record for the 2:30 calendar. First matter I'm going to call is matter involving Taylor Linky. Who's saying I take it you're here on behalf of Mr. Are you expecting him to appear? Or? Okay, if I'm willing to accept his non-presence, if it's up to you. He's got 2 citations on the docket. Both of them were in collections in FDA status. They've got a little bit of a history. Could you speak up a little bit? The acoustics are here and horrible, and my hearing is not recovered quite from a 10-hour airplane trip. So if you'd speak into the microphone,
Okay,
that'd be
I
a.
will. So, Your Honor, when he first got these tickets, he did contact me, and I think he kept talking to the court about how he talked to a lawyer. That was me. And I had just told him, request contested hearings. After that, I think he was in a panic, feeling like he couldn't come to court without a lawyer. And that led to some very strange conversations with the clerk's office. I believe, and I don't have the evidence with me today, that he had insurance during both of these tickets. He had originally truly wanted to contest them, given some of the circumstances. Right now, I'd like to see him get relicensed, which he can't do if these are holding it. So my request is that the tickets come back, and maybe we can set another hearing and I'll have him here.
What the farthest I'm willing to go at this point, I'll revisit the amount of the fines, which went into a total of $1,790. I will significantly reduce those. If we do, if there's bring in proof that he did have insurance on this date, I'll give him the benefit of the $25 D on those counts. But the best I can do, given the entire history of the thing, is to give him a significant financial reduction.
Okay.
His record is have you seen his driving record?
Yes, I have, Judge.
I'm surprised you can get insurance at all, actually, based on the number of speeding tickets he has. But hey, if he did have insurance when he was cited on either occasion, I'll give him the benefit of the.
Okay, perfect. Do we have some deadlines or a proof date or a return date, or what can I tell him?
Do you want to reset this for another hearing at the
Well,
later? What do you want to? I'd like to hear from him a little bit about his financial situation. I'll give him a substantial break in the thing.
Okay, so yeah, let's try that.
Well, then why don't we set it to the, how about June 20th? Let's give him a little bit of time here.
Yeah,
If he's a
sounds-
roofer, I don't want him, this is kind of the season for what he's doing.
First time still.
That's fall rains come, he's going to be more amenable to going to court. But how about June? Let's set it for June 20th, 2:30 in the afternoon, and
Perfect.
if I'd like him to be here and or at least know a little bit more about his financial situation and have proof if there is
Yes.
about the insurance.
That certainly works, Your Honor.
And you've got the dates of the citations.
Yes, I
If
have.
not, we can
I have
certainly-
copies of everything, so I'm in good shape.
October 8th. And probably a really good idea to slow down a little bit.
Mhm.
Yeah, that's especially when you're getting $600 tickets.
Guy, and insurance costs the earth to begin with, even if you're a good driver. All these things.
We don't think ahead. We don't think ahead. Well,
Okay.
we'll readdress the matter. It's been going on for quite some time. We'll go on with it a little bit longer.
Are the tickets can they come out of collections now to? 'Cause
That's what I'll do.
Okay, Taylor, and then he comes back. And
That's when we
address it.
reach a resolution. Typically what I do is say, hey, we'll remove this from collections. If you can make a down payment of some kind.
Sure.
See if
So-
you can bring some money
Yeah,
on
I'll
it.
tell him. So either
I'll significantly reduce that, but then I'll have him sign a TPA, time paper, for the balance that he owes, put him on a payment program, and of course, recall from collections.
Okay, wonderful. Thank you very much, Your Honor.
Tell Mr. Linky to slow down, save his life, and reduce his insurance premiums. Chris, take care, have a good day.
Thanks a lot.
And we'll deal with it again on June 20th. Say, hey, Chris, take care. Call the matter of Gina Pauling. Ms. Pauling, been a while since I've seen you. Come on up and have a seat. You were cited for expired registration and no insurance. You've asked for a contested hearing. That means I didn't commit the infractions. Is that the way you want to proceed?
Oh, you know, I was already in the park. Hit her lights, pulled me over. This was I got the tell.
Now,
I
if
mean,
it's,
I just feel that I was already, we're going down.
the important thing is not when she hit the lights. That's important in terms of you stopping, but the important thing is when she saw you driving.
Oh.
If she saw you driving,
I was on private property by the time,
oh yeah,
you know.
that's not really a defense. If she saw you driving, and of course,
Well, the officer told me that when you're going to private property, you know, I don't remember which officer, but he said that if you're on private property, you have to wait till you're on private property, before you can issue a ticket. And the same applies if you're entering, if you get on it, that would be, and I understand, I know that's why she hit her lights, so I would know that she was in, but I just feel that I was already in the parking lot, but that's
may have
not how
been,
it works.
but the important part is if she saw you driving on the public roadway.
Okay.
That's, I'm willing to mitigate the tickets, reduce them considerably. No insurance, $5.59. You can't afford that and insurance. Do you have insurance now or?
No, too many tickets, but I can't afford it anyway. I'm homeless.
How about the registration?
Yeah, I got the.
Wait.
Tab.
Why don't we, in view of the fact that you have that, let's reduce no insurance from $5.59 to $150 and then dismiss the registration charge. That fair enough?
Yes.
I'll sign an order to that effect. How have you been? Haven't seen you in a while.
Yeah.
You say you're homeless now?
Yeah.
I'm sorry to hear that. Is there anything you can do about that? I'm sorry to hear that. I don't know what the situation here in Yelm is about that, but I know Olympia has their tiny home village. I just really don't know that much about it. Ms. Pauline, I'm signing an order to that effect now. I'd like you to, make the payments, but if you can't, let us know. Let us know.
Yeah, if I get a ticket, I pay it. I don't want to. That's wrong.
Will you take care of yourself? I've signed an order. You can get a copy of it at the window outside the courtroom to your left, and good luck to you.